Great. So it's 2 past the hour. I'm sure more people will filter in as we go, but we've got a very tight schedule. So I'm going to get started. So hello, good morning, good afternoon. Welcome. My name is Sarah Hill Smith, and I will be moderating today's panel on navigating directors' duties in an evolving world. Quickly about me, I am a UK qualified lawyer, and although I'm currently working at Client Earth, I'll be speaking today in my personal capacity as editor and co-author of the Directors Duties Navigator, which is a report that I will introduce shortly, and former CCLI consultant. So I am a UK lawyer, as I mentioned, and I wrote the UK section of the Navigator, as well as introductory commentary. And I had the pleasure of working with all of our panelists and speakers today across all 20 jurisdictions. So a few points of housekeeping to note before we get started. The first is that the session will be recorded. We do encourage you to come off camera and show your face if you feel comfortable doing so. But if you don't want your face to be included in the recording, then please do stay invisible with no camera on. We have a lot of discussion today, and we imagine that it will throw up some questions. So please do put questions in the chat throughout the event, and we will have a dedicated Q&A session later. Next slide, please, Kirby. So as mentioned, we have a very packed agenda. We will be, after I finish babbling, we will have a keynote address from Daniela Mateus. We'll then move into a legal panel with authors of different sections of the Navigator report, closely followed by a more commercial director-led breakout session. So we'll be workshopping what the legal findings and developments mean in practice. And then we will feed back to plenary and have a Q&A section for all of the speakers that you would have heard from. And then we will finish at 4:30. So next slide, please. So as mentioned, we are here today to formally celebrate the launch and explore the findings of the Directors Duties Navigator Climate Risk and Sustainability Disclosures Report, which focuses this time on Europe and the Americas. This report is co-produced by the Commonwealth Climate and Law Initiative, or CCLI, and Chapter Zero Alliance. CCLI is a legal research and stakeholder engagement initiative that produces legal resources and tools and legal opinions on directors' duties in relation to climate and nature risk. Chapter Zero Alliance is a global director network that enables directors to implement climate strategy and governance through tools and training and upskilling and resources. And you can read about both resources on the, organizations on the slide and also on our website. Next slide, please. So what is this navigator that I've mentioned? Back one slide, please. Thanks. What is this navigator that I've mentioned? So if you are connected to me on LinkedIn, you'll probably know all about it because I haven't stopped posting about it for the last 2 months. The Directors Duties Navigator is a report that was published in January. It's a comparative guide looking at 20 jurisdictions across Europe and the Americas. And it forms part of a wider resource, which is the Global Navigator that covers 35 jurisdictions, including Asia Pacific and Africa. And all of the dots on the map on screen are included in the resource. And I believe my colleague will drop a link to the resource shortly. The Navigator maps out in each of these jurisdictions in plain English and in the local language where appropriate, key legal and regulatory frameworks around climate and nature and corporate reporting and disclosures. The report clarifies directors' legal duties and obligations when responding to material climate and nature-related risks. And it helps directors build a strong baseline of knowledge that enables them to adapt strategy and governance in line with quite rapidly shifting external environments and contexts. And this, we hope, helps embolden directors to be very proactive in climate and nature governance rather than taking a wait and see approach until they feel like the dust settles, because from experience, the dust never really settles. This year's report also includes short key takeaways documents, practical tips, and commercial insights from leading lawyers and directors, and we're really privileged to have many of those speakers with us today. Before we really begin, I just wanted to say a few words about why this matters now. So we're living through a time of not just political fragmentation around sustainability and ESG, which we'll of course unpack more as the session goes on, but also around huge geopolitical instability. Events unfolding in the Middle East and in Ukraine not only have a huge human impact, and our thoughts are really with all of those affected, but also significant business consequences. Geopolitical instability directly shapes business strategy and corporate risk, capital allocation, and reporting decisions. And it hits the bottom line through various transmission channels, which we will explore later, I'm sure. And the consequence is that already time-poor directors are faced with urgent and conflicting priorities. So it's reasonable for directors to ask, in a context where geopolitics and AI and cybersecurity are rapidly rising up the boardroom agenda, and where sustainability and climate seem to be slipping, and I want to maybe debunk that myth a bit later, why should directors focus on climate and nature now? Why is this navigator so important? And there are 3 points I want to come across in this session. And the first is that climate change and nature loss don't sit outside of these external factors. They interact with them and often amplify them. So, for example, climate-related risk and exposures and impacts can amplify organizations' vulnerability generally, can undermine their resilience and ability to react to shocks caused by geopolitics, for example, disrupted trade routes, which we're experiencing at the moment in the Gulf. Second, and related to that, is that climate and nature-related risks aren't a new category of risk. They are not conceptually different to other financial risks. In fact, they are just examples of material financial risks. So when thinking about climate and nature, it shouldn't be done in a silo. And I'm sure it will come across in the panel, but it very much comes across in the report. All contributors to this report have encouraged directors to integrate climate and nature risk management into existing enterprise-wide ERM systems, controls, and various other measures and tools. The third is that whilst political backlash and regulatory rollbacks may lower climate-related transition risks, they don't diminish climate risk in general, and nor do they alter directors' core duties. And across all jurisdictions in the Navigator, the authors emphasize that directors remain responsible for exercising care, skill, diligence, and overseeing material financial risks and opportunities. And as climate change and nature increasingly affect companies' bottom lines, and I don't need to bring up statistics from all of the reports that we've seen this year emphasizing how they already are manifesting, so long as they are crystallizing and impacting the bottom lines or threatening to do so, it still remains within directors' legal duties to actively manage those risks. Together, these dynamics amplify the need for decisive, informed, and forward-thinking leadership. By simplifying the law, the Navigator aims to empower and embolden directors to take decisive action in response to climate change and the nature crisis, which remain, in my opinion, and in many others, I'm sure, the most existential issues of our time. Next slide, please. So before we move into the main session, I want to just do an icebreaker to see who's in the room. We've got a very international panel, so it would be great to know who is in the audience. So I believe that the poll and the questions will pop up on Zoom, and they should be quite quick. So we're not going to allocate too much time to this section. We just want to know who you are, where you are, have you heard of the Navigator before? What are you hoping to get out of today? And just your general thoughts on climate-related risk. Interesting. So we've got mostly directors and lawyers, which is expected. Some academics, mostly in Europe, North America, Latin America is good representation, especially given how early it is in some jurisdictions. So thank you for dialing in. Mix about who's heard the Navigator or not. Hopefully that will change in the session. Strategic insights, I do hope that we will be able to deliver those, and it's good to see that most people recognize the materiality, the present materiality of climate change and nature loss. So that's really good. Thank you all for your participation. I'm now delighted to hand over to the first expert speaker that you will be hearing from today. Daniela Mateus is a non-executive director, a finance and ESG expert, and is co-chair of the FEA, the Financial Experts Association. And Daniela is based in Germany and will be giving an insight on why climate and nature risks are core legal duties for directors. Over to you, Daniela.
Thank you, Sarah, for the nice introduction and for the invitation. It's a pleasure to open up this webinar with a keynote and a simple message, which is we are at a turning point today. Today, sustainability is not longer on the top of the agenda of boards. As you mentioned before, geopolitical crises dominate the headlines. Some political voices even question human-made climate change. Investment are shifting quietly away from climate-positive projects. And despite record temperatures and billions in damage from extreme weather, the sense of urgency is fading. Across Europe, many companies feel overwhelmed by reporting requirements. Boards feel this fatigue as well. And at the same time, and you mentioned it as well, AI has captured the spotlight. Productivity gains, transformed value change, entirely new business models. AI is shaping board conversations more than almost any other topic, and climate has slipped into the background. So, yes, by today, I do see climate action in a moment of crisis. But I also believe it also marks a moment of opportunity. Crises force us to refocus. They cut through the noise. They sharpen our sense of leadership responsibility, and they create the space for boards to reset priorities. And this is where non-executive directors have an extremely powerful role. Our responsibility is not primarily defined by CSRD in Europe or CSDDD or any other framework. Regulations set boundaries, but they don't define ambitions, and they certainly not define leadership. At its core, our task is to look ahead. And climate change presents two central challenges that are demand exactly that. First, it is all about direct business risk. We are already seeing production disruptions due to heat or flooding, water shortages in industrial regions, volatile supply chains, and rising insuring premiums to the point where insurers are withdrawn from high-risk markets. These developments raise immediate strategic questions for boards. How do we protect our assets? How do we safeguard our employees? How do we secure access to energy, water, and raw materials? The answer will determine the resilience of our business models. Second, companies have a responsibility to be part of the solution for climate protection. This is not easy in economically demanding times. Short-term pressures often push climate ambition down to priority list. But meaningful climate action requires courage. It requires decisions that may not show immediate results, but are essential for the long term. And also, 2050 may seem far away. The strategic direction for those milestones must be set now. Climate strategy is rarely linear. It requires continuous adjustments as technology and markets and geopolitics evolves. But it also requires consistency and, above all, leadership. And this is precisely where I think board can make a difference. We have to turn this moment of crisis into a moment of transformation by building more resilient companies, strengthening competitiveness, future-proofing business models, and creating lasting value for society and for shareholders alike. This is the opportunity in front of us, and it's one we should embrace with clarity, with conviction, and with a long-term view. And I'm very much looking forward to discuss that with all of you in our breakouts.
Thank you so much, Daniela. I love that. Regulation sets the boundaries, but don't define ambition or leadership. I mean, we often talk about reporting not being an end in and of itself, but a means to achieve something much more transformative and that drives value beyond compliance and reporting. So I really resonate with your remarks there. Brilliant. So let's move to the next session. And Daniela will be coming back later to moderate the director-led breakout room. So if you want to hear more from her, you're in luck. So next we will be moving into a panel discussion with the lawyers who wrote several sections. So if you could pull up the slides again, their bios will come back on screen. So I'll be joined by Jessie Medlong, who is a sustainability lawyer and impact advisor and of counsel at DLA Piper in the US. It's very early for Jessie, so we are very grateful for him joining. Jessie authored the US section. From Brazil, we'll be joined by Ana Lucy Grizzi, who is a non-executive board advisor, a lawyer, and a senior advisor at ALG Climate and Nature Capital Governance. Ana Lucy wrote the Brazil section. And finally, by Dr. Sabrina Bruno, who is a lawyer and professor of corporate law. She's a NED and co-founder of the Chapter Zero Alliance and Chapter Zero Italy. And Sabrina and I were very busy in correspondence because Sabrina wrote two sections of the Navigator. She wrote the EU and the Italy section. So we are very lucky to have representatives from 5 jurisdictions in the Navigator, if you include the UK, for me. And I'm really looking forward to unpacking the findings with you. As mentioned, please do post Q&A in the chat. I believe that function has now been resolved, so apologies for the inconvenience in the first place. So an opening question to you all, quick fire round. I'm very interested to know about 1 to 3 governance or climate related trends in your jurisdiction that are most impacting directors. And why don't we start with you, Jessie?
Sure. Thanks, Sarah. I think in the US, perhaps the most, and there's a lot going on, as was mentioned, but I think the most meaningful, the most impactful trends in the US begin, of course, with the federal deregulatory agenda, and I think on the upside of that, the corresponding action of states to try to address climate change. The second is the US's move away from international obligations. When I say there's a lot going on now, there was also a lot going on as we were putting the final touches on our chapter. And one thing that was noteworthy was the decision by the US to withdraw from the United Nations Framework Convention on Climate Change as contrary to the interests of the US. This is sort of, I don't want to be too grim, but it's cast a bit of a pall on how we look at climate action right now, and I think its long-term impacts are difficult to gauge. And finally, there's an increasing trend among state attorneys general in the U.S. to cast any kind of coordination on issues that are sort of ideologically opposed to their own preferences as anti-competitive. And so we're increasingly seeing initiatives that are, collective action by companies. And I think it's fair to say that climate action is collective action, and casting that kind of participation in a net zero alliance, for instance, as anti-competitive. And we don't have the same kinds of rails that other countries have put in place to protect this kind of action from antitrust laws in the US.
Yes, and you had quite alarming news this week with Vanguard settling one of those lawsuits, which was quite shocking. Thank you very much, Jessie. Sabrina, we'll go to you next to give a EU and Italy perspective.
Yeah, sure. I will focus on Europe perspective. Well, a lot is going on in Europe as well. But I must say that at the end, despite all the struggle that occurred in the past months, in particular culminating with the repeal of Article 22 of the Due Diligence Directive, this article originally required companies in the scope to adopt and implement an energy transition plan. And after a political struggle with also lots of influence from the oil and gas sector, the result has been to repeal the article at the end of last year, and this was confirmed, finally confirmed on 24th of February, a few days ago. So what happens now? So the formal duty to adopt and implement energy transition plans seem to be repealed. But is it the case? Well, I don't think it is the case because luckily enough, the other directive, the CSRD and the and the delegated regulation, which was enacted with it, containing the so-called ESRS, the European Reporting Sustainability Standards, still make a specific reference to adoption of energy transition plans, also identifying precise information to be included in the energy transition plan, where companies shall explain and disclose whether their business model is resilient with reference to climate change, as well as identifying IRO, that is impacts, risks, opportunities linked to climate change. So this is still in force for those companies that are in the scope. That is all listed companies with over 500 employees and plus insurance companies and banks. So this has not been changed. What happened was that the ESRS have introduced more discretion for directors. So if you want to come back to this point later on, but also want to stress that nothing is changed, also considering all the banking and financial regulations, which are still in force. And it is, of the news, the latest news, a few days ago, ECB, the European Central Bank, that imposed a penalty on Crédit Agricole equal to 7.5 million euros because Crédit Agricole did not adequately assess climate risks, so disregarding what the recommendations by the ESB have been. So, from the financial market side, there has been no change, basically, absolutely no. So, ECB, EBA are still going on the same direction as it used to be. On the other side, more discretion has been introduced for directors, which will make directors' choices much more difficult, with a higher risk of liability. And if you want, we can come back on this later on.
Thank you very much, Sabrina. We will pick up on all of those later, I'm sure. And then finally, Ana Lucy, please give us your highlights from Brazil.
Sure, Sarah. So for Brazil, we have two major climate trends impacting corporate governance. Right now, we are discussing carbon pricing. Brazil enacted its carbon market rule in December 2024, and we are in the run to implement it. So up to 2030, we expect to have the Brazilian emissions trading system, such as the EU ETS, running here, and then giving carbon pricing to all our assets. The other major trend refers to climate and nature-related risks and opportunities disclosure, as Brazil was the first jurisdiction, if I'm not mistaken here, to adopt the ISSB standards, so S1 and S2. We are currently working on that. So for boards, we actually have these two matters in the agenda right now. We have the sustainability committees working together with the auditing committees and the risk committees, the strategy committees, in order to understand, first of all, how to collect the data for the disclosures, because we don't have the data, or we don't have the data and we do not have internal controls for the data. So we are upgrading it. And of course, the next step, considering these two major trends ongoing, for climate, but also for nature. In Brazil, every time we discuss climate, we are also discussing nature for obvious reasons. The next step will be to understand and really deal with risks and opportunities from climate and nature matter within the company strategy. And then, of course, this will be a board matter, and we need board members and committees deeply involved on these matters.
Fabulous. Thank you so much. And I was very struck by the different approach taken in Latin America to dealing with climate and nature together holistically. It's different from the approach taken in Europe and elsewhere. So I'm now going to pick up on some of the points that have been made already. And this question is directed to Jessie and Sabrina kind of separately. Both the EU and US have seen quite a lot of regulatory upheaval, let's just say, in the last 12 to 18 months around sustainability and climate regulation. You've already slightly answered this question, so I'm going to bundle it with the subsequent questions, and you can take them together and put your spin on it as you see fit. But the first question is, are things really as bad as they seem? You know, the omnibus kind of cutting the scope of CSRD and removing transition plan disclosures, and also the federal level action at the US, you know, the overturning of the endangerment finding and very high profile litigation and anti-ESG legislation, you know, it really grabs headlines. But I know from working with you both on this report that there's a lot going on that doesn't capture the headlines. So are things really as bad as they seem? And then generally, how should directors respond to these developments in the US and EU? What are their duties and responsibilities, and what guidance and tools exist to help them? Who wants to go first? Jessie, you're off mute, so you've got the head start.
Sounds good. Well, look, I don't want to sugarcoat it. The current regulatory environment in the US is difficult and unpredictable, and particularly with respect to climate and action and sustainability, given the scale and urgency of the challenges that stakeholders increasingly expect private industry to address. But regardless, the need to be addressed if they are to be, this difficult environment really could not come at a worse time. But you know, we do see states like California and New York trying to jump into the breach. California is the fifth or sixth biggest economy in the world. It's not nothing that a state with an economy of that size is is implementing rules to require climate disclosures so that we can start to understand what kinds of risks companies face, and also get a better sense of the GHG emissions of the largest companies that do business in California. You know, these states, they understand that climate-related physical risk and climate-related transition risks and opportunities are real. They are often material, which means that companies already have some obligation to, at minimum, disclose them, but often to address them, to mitigate them as well. And these states are not waiting for permission to manage those risks through their own regulatory agendas, and many companies are also not waiting to manage those risks and seize those opportunities. A lot of directors, a lot of officers understand already that these risks are real and material, and so I think, you know, it's an interesting moment. You know, I recall I was in, I believe, Marrakesh in 2016, and we were seeing, you know, it was the first time that President Trump had been elected, and the head of the U.S. delegation to the UNFCCC basically said, look, this may look grim, but the reality is that the mega trends that are driving the energy transition are not going away with any one government, regardless of how big the emitter is. So I think we have that to look forward to, which is a very robust transition that's already underway. And so that's where a lot of directors find themselves. And in terms of how they then rise to the moment, what they do in you know, this difficult environment, I think they have to stay the course, essentially. You know, because these risks, the climate-related risks, are real and material. directors, those responsible for disclosures and the like, have to assess the materiality of these relevant risks and opportunities on a case-by-case basis. They have to understand, is this risk material? Not is this a climate-related risk, but is this climate-related risk, along with the suite of other risks that affect the company, material? And if so, then to address it appropriately. At the same time, as a lawyer, maybe I'm a bit of a blunt instrument, but I think that you need lawyers. I think it's important for directors to consult with antitrust counsel about the risks of coordinated action versus individual voluntary initiatives in the US. And they should be as explicit as possible about the business reasons for various approaches. The business judgment rule gives a lot of latitude. So I think if as long as disclosures aren't saying things like this doesn't really matter to the business, but we're doing it anyway, or we think that this is, not a profit driver, things that would be, strange to see in climate disclosures, then you there's a lot of latitude for those kinds of disclosures. But more importantly, directors should be explicit. Just say, how does this affect the business? Because if stakeholders can see explicitly why these risks are material, what the business justification is for these things, as opposed to just sort of seeing them happen and taking directors' words for it or companies' words for it. That's going to be one of the best defenses, because the business judgment rule does generally give so much latitude to companies that are just trying to preserve and generate value from their companies.
Yeah, and that's a really interesting point, actually. A lot of other states don't have as clearly defined business judgment rule, but they have a common law business judgment rule, or a business judgment rule kind of copy in practice. And generally that is the case. If directors can show that they followed the process and they've done the thinking and they have some reason to justify the action, that in itself is a good protection against liability. Sabrina, over to you to talk about the EU.
Yeah, as I already said earlier on, actually, it's not as worse as bad as it looks, because, as I said already, despite the repeal of Article 22 under the due diligence directive, there are still the CSRD and the ESRS, which are enforced, and they oblige companies in the scope. Okay, scope has been reduced, but most important companies, again, those listed companies with over 500 employees, and banks and insurance companies are obliged, and since 2016, so I mean, they are already on track in this direction. They have been already adopting energy transition plans. The most virtuous companies are in this direction, and they have not changed at all. So there has been no upheaval in this respect because they have already climate change, but all Europe legislation, as like in Brazil, makes reference to climate and nature-related risks and opportunities, impacts, negative and positive impacts that have been identified precisely. The European legislation, I think, was a good one, a good way of regulating the topic, because this information to be disclosed have been standardized under ESRS. What has happened after the Omnibus one, which was the only one referring to these topics, what was changed is just to introduce more elements of discretion for directors, so basically widening their business judgment rule, which made the task for directors even more difficult, because it would have been much more simple to have some standardized information to follow. They would have they could have been a sort of a safe harbor for directors. Explaining they fully complied with what was originally required under the ESRS. While now, after the Omnibus one, what happened was that it was explicitly stated that directors could, in theory, I think this is just a theoretical justification, could in theory decide not to publish an energy transition plan. I think this is a theoretical decision, because if they have already identified risks impacts that are material, of course, for the company, opportunities referred to climate change. At that point, they must, it is their duty, if they want to comply with the duty of care, it is their duty to adopt an energy transition plan, which is the tool through which these risks can be well managed and mitigated. Okay, so I mean, nothing has disappeared. It has to be justified. Other elements of discretion that have been more recently introduced with reference to the energy transition plan concern the fact that it's possible for directors, when they draft an energy transition plan, to decide whether referring to a climate scenario or not, whether referring to emission reduction targets based on conclusive scientific evidence or not, whether, I mean, and up to the omnibus, what was required was to fix a plan to reduce emissions with reference to 2030, 2050, with intermediate timelines. Now this has disappeared, and there is just one timeline, 2050. But an energy transition plan that does not show any climate scenario, does not show any intermediate timeline before 2050, or is not based on conclusive scientific evidence, would not be coherent, would not be correct. So, and while the same legislation still requires that the energy transition plan shall be coherent also with the investment decisions, financial planning decisions, drafting of financial statements. I mean, those are not just disclosure requirements, not at all. They have profound implications in the management of the company, in internal control, in the enterprise risk management, and this has not changed a lot. I mean, so directors must be very careful if they justify lack of adopting an energy transition plan. And also these new, provisions very much risk to foster greenwashing. So, I mean, I think directors' duties and directors' conduct have been, is now much more complicated. So they need to be more competent and more confident on these topics.
Excellent. Thank you so much, Sabrina. So Anna Lucy, I'm going to roll the next two questions together. So Brazil is fast emerging as a regional leader, as you've picked up on already, throughout Latin America in climate and nature law and regulation. And I'm very curious to know to what extent developments externally, so at US and EU level, are impacting the context in Brazil, and otherwise generally what's driving this impetus in Brazil, and how are directors responding, and I guess what's needed to continue pushing it up the boardroom agenda in Brazil.
So first of all, as an emerging economy, for sure we are impacted. When in terms of the US, we have here the greenwashing. It means that companies that were really working with climate and nature relevant matters, financial matters, they keep on doing that, but they started not to tell the market about it. The ones that were just advertising on net zero plans, and they were only plans, just stopped what they were doing. So this was the first impact, in my opinion, derived from the USA geopolitical matters in terms of climate and nature. In terms of Europe, we have direct impacts when Europe postpones, for instance, the EUDR, the free deforestation law, because we were expecting that traceability and quality of products would be already mandatory, so we could enhance our supply chains, and boards were already discussing how to enhance quality of the supply chain. And when I mean quality, I mean either for environmental traceability, so to ensure that products are not really derived from deforested areas, illegal ones or legal ones as of the date foreseen by the EUDR. But we were also discussing about human aspects of the supply chain. Once it is postponed again, then we get the boards, well, this is not a relevant matter anymore. We have the war ongoing. We have the energy security issue right now because of the gas prices, again, for this new war. So it gets messy, Sarah. Every time we have these bumps in the international scenario, it gets messy here. And we have reordering the priorities at the board agenda. As for what is driving us towards climate and nature matters in terms of corporate governance, I would for sure tell you that it is regulation. We started with the Central Bank of Brazil in September 2021 when it regulated ESG aspects in terms of risks and opportunities for banks. So we have been working within the financial sector as of 2021 in this view of climate and nature as a risk and opportunity for our financial sector. And it makes all sense because the Brazilian GDP depends almost 30% on agriculture and then another relevant percentage on mining products. So we are nature dependent and these activities are impacted by climate risks, especially the climate physical risk. So it all makes sense. It is for sure regulation. We started with the central bank. We have now the Capital Market Supervisor Authority just imposing the ISSB mandatory disclosure for the public listed companies. We have the Insurance Authority also as of June 2022 working with and imposing this climate and nature assessment for insurance companies. So we have the whole scenario and also the Pension Fund Authority working with climate and nature matters as long as they are material relevant for the companies. We have the whole financial sector working on it. So regulation for sure is driving us to move the climate and nature matters to the board agenda. And to your last question, boards now are much more involved, but I would say that boards from climate intensive businesses. So we have fertilizers, we have steel, iron, cement companies there, or we have boards from agribusiness sector deeply involved with these matters. I wouldn't say that boards from tech companies are deeply involved, even though we have the energy issue. But we are starting to discuss more. We have boards worried a lot with the disclosure that will have to be done under S1 and S2. So they're just starting to understand and have their training on this matter, which is perfect. We are on the journey.
That's excellent. Thank you so much. So we have 5 minutes left of this section of the event. So I'm going to try and roll the last few questions together. There are obviously challenges for directors that operate multi-jurisdictionally. You've all picked up on different frameworks that exist in your jurisdiction and different risk profiles. What's one piece of advice that you'd give to directors operating in international context to manage these risks? I guess what's the liability risk if you want to touch on that if you get it wrong? And if you're looking forward, what would be the single most important development? So I have not done you any favors there in distilling the question. So maybe just pick up on any element that resonates with you. Jesse?
Yeah, there was a lot there. I don't want to take up. I don't want to monopolize our last 5 minutes. But in terms of like what directors can be doing now, I think the key is to start thinking about these risks. In the U.S., the business judgment rule, as I mentioned earlier, really insulates a lot of decision making, and so much of a director's duty boils down to risk and to an additional extent that's not as relevant here in most ways, but also, ensuring that you're maximizing opportunities for the company, that you're not, of course, not self-dealing and things like that, but putting self-dealing, these sort of malfeasance aside, the idea of ensuring maximal opportunities for the company's well-being ensures seizing those opportunities and also identifying the risks. Really, at the end of the day, what gets measured gets managed. And if you're identifying material risks, regardless of whether they're climate related, you have a fiduciary duty to disclose and act on those risks. The best way to address climate related risks is thus to identify them, to formulate a coherent business positive plan to address them. And if you're waiting to see because you're afraid of what material risks might be hiding just out of sight, that doesn't make the risks go away. It just makes them harder to mitigate. And I guess, again, apologies for taking so much time, but we've heard a bit about green hushing too. But this is a very in terms of risk, I think a lot of directors in the US see green hushing as the lower risk option. We don't have a framework in the courts where we do most of our regulation, unfortunately, that for having some kind of downside other than failing to realize the opportunities of climate action for green hushing. And so, at least at this point, you're going to, I think the key is for directors to think about how they can avoid that green hushing trap, because it is sort of the easiest, the path of least resistance for risk management. But at the end of the day, risk management is the real key here.
Perfect. Thanks so much, Jesse. Sabrina, over to you. And just to say, you will have the opportunity to ask questions of the panel later. So yeah, we will hear from you again.
Okay. So there are potential risks of liability in Europe, I think, for misleading information on reporting, on the reporting, on the sustainability report. But also, I mean, in case of lack of coherence between information in the sustainability report and in financial statements. But also, I mean, potential liability for breach of the duty of care in case risk management has not been taken into due consideration by directors, and there are damages or potential damages to the company. I want to remind two cases that, of course, are cited in the Navigator. That, I mean, refer to the contents of the energy transition plan, the Client Earth against Shell case, which was just the first, so far the only case against directors personally, where the request was an injunction before courts, an injunction ordering directors to change and modify the energy transition plan, making it more coherent. Basically, the same claim was raised by Mail Defiance against the Shell in before the Dutch court. We can say yes, that we can say in both cases plaintiffs actually lost the case. In both cases, what won was the business judgment rule, making reference to what Jesse was saying. It is true, but both cases were not based on the European legislation. One, because it is a UK case, and the Dutch case was held before the European legislation. So I think that potential liabilities are bigger if plaintiffs make reference to the contents of the European legislation.
That's really, really interesting insights there, Sabrina. And I like that you've taken a different angle as well. So we're touching on all the three questions that I asked. So Anna Lucy, over to you for final closing remarks.
Sure. So I would advise directors here to understand climate and nature matters and understand if they are material from a financial perspective. Once they are material, please do take care, be either on the corporate risk management systems to ensure that it is ongoing and that you have the data and that you have a mitigation plan, and also from the opportunities perspective. Of course, I wouldn't be too worried about liability right now, because I wouldn't say that in the next 3 to 5 years, we're going to see directors held liable by our capital markets authorities or even by judges here in Brazil, because they have not fulfilled that fiduciary duty in terms of climate and nature. But I would be worried regarding the longevity of the business if risks and opportunities are not managed right now. So this would be my advice for the board members.
Excellent. That's very good advice. And I think all of those messages ring true for other jurisdictions in the Navigator as well. So we're now moving over to the interactive section of the workshop. We're going to be split into breakout discussions. These will be looking at North America, Latin America, and Europe. In this, it's going to be more commercial focused than legal. So we will be essentially discussing how these legal and regulatory developments manifest as commercial considerations. So the discussion focus will be 3 questions. What are the 3 risks or trends? I mean, maybe because we're running a little bit behind, you can skip to the last 2 questions, which are barriers to board action. And then the last question is ways to unlock those obstacles and move this up. So these sessions will be led for North America by Gwen Megisa, who is a non-executive director in America, and yeah, and advisor, a board advisor. Dina Mex will be is from Chile, and she'll be leading the Latin America breakout session. Dina is a board director. She's a director of, sorry, it's really small. Sorry, Dina. Colibri, Chile. She's a CGI ambassador and a member of Chapter Zero, Chile. And then finally, Daniela Mateus, who you've heard from before. And I believe the speakers that you've heard from will also join the relevant breakout discussion. So I think the option will pop up. And you'll have the opportunity to introduce yourself in the breakout discussion. So please do pick which one you want to go to. And then we will convene back here at 4:07. So lightning round discussions. But thanks everyone so much for the panel discussion, and we'll see you back here soon. Hi everyone, welcome back. I hope you had a good discussion in your breakout rooms, and apologies if there were some of you caught by the inevitable tech issues. I think we may still be waiting for some people to rejoin the main room. I don't know how to check if people are still in the room. Maybe we've just lost a few people in the transition. But you should have all nominated a speaker to summarize your discussion. So if we could start with the Latin America room, please do summarize in 1 or 2 minutes the main challenges and opportunities that were discussed.
So that was Montserrat Diosdado. She's our representative. The system is not allowing me, but I do have an audio, so not video, sorry. So I'm gonna just read something that we could speak. We are only had a little time, but for example, first we could see one of the main trends in the region, especially in countries such as Colombia, Chile, or Brazil, is that we are seeing a lot of regulatory disclosure regarding climate and obviously nature also, but also how these countries, especially for example our country here in Chile, has already declared the climate risks as financial risks, and obviously changes the conversation between the boards and between the financial decisions that the companies take regarding climate and nature. Also, there was Julian, that he's from Colombia, and he was he's working in his PhD in Europe, and he was talking how he had been seeing in his investigations and throughout his work how an interdisciplinary vision is needed when you reach to speak about climate change and nature-related risks, because we can see some boards having more a tunnel vision that it's driving the boards to run decisions. Sorry, I have a kid here. Also, we come also from countries that are very high dependent on nature here in Latin America, and that's why we think that some boards are more prone to work towards preserving what is our main source of income also. And regarding Mexico, we could see how these climate related and nature themes are getting more professionalized, but it also drives more pressure for companies. For bigger companies, it's very manageable. However, for SMEs, medium companies, it's really challenging because they're asking for a lot and maybe with much less resources than the big companies. I think that could be a good summary of our discussion.
Excellent. Thank you so much. And it's lovely to meet your small human that's contributing too. Let's move on to North America, please.
So we had a few representatives from around the world. So Charles, calling out of Barcelona, is our spokesperson. Charles?
Yeah, hi. Can you hear me? I don't have my video on,
Yes.
so you're all missing out on my video.
I know what you look like, and I can vouch that he's very gorgeous, and you're all missing out.
Thank you, Sarah. Yes, I am very gorgeous. So the main obstacles, and I'll just be quick, we had a good discussion, and it's fear of pushback from the anti-ESG lobby that have really brought litigation, very litigious, and have brought actions against private asset managers in a number of states on the basis of them taking ESG or climate forward investments. A lack of legal clarity of what is and is not required by directors, a misunderstanding of economic and financial modeling, a lack of an educational framework, and the diffuse nature of climate-related risk disclosure between jurisdictions, and the lack of uniformity in determining materiality between jurisdictions, so that directors are confused about their obligations. Thank you very much.
Brilliant, thank you. And then finally, Europe.
So Mike Clark is taking over. He's our spokesperson. Maybe you can unmute him, Mike.
Can you hear me, Sarah?
Yes, loud and clear, Mike. Thank you.
Apologies, my camera doesn't seem to be on, though it is for me. So in our discussion, Annabelle Nelson made the very wise point that time horizons are very different for different actors, which I totally endorse. Moritz identified two pieces of work which I'm peripherally involved in, which are clearly they're very important. I talk about societal risk and financial risk being very different risk paradigms, and the major barrier being the lack of realization that we need that. To the questions that you pose to the group, frankly, sustainability is second order. It's climate, climate, and climate, in my view. And be careful, this is a pitch, because I'm on the advisory board of VIZARD, VYZRD, and self-interest is what sort of rules the world. So last week, I helped organize a in-person roundtable with lots of lawyers. And I think it's a gentle challenge to something you said earlier, Sarah. I can't remember what you said, but the proposition is that very soon, if directors in an M&A transaction do not do enough to check out the data room of the company they're buying, and one route, this is the pitch, they get a visit assessment, which actually values companies allowing for climate change, discuss, they have litigation risk now. This interested lots of lawyers. There's other things that VIZARD clients do, but I'm not here to pitch. But I just want to mention that capitalism is beginning to heal itself, which is why I'm on the advisory board of VIZARD. Thanks.
Thank you. And if anyone wants to reach out to Mike afterwards, please do feel free. We're now going to move into the Q&A section of the session. So all of the panelists and breakout room hosts are available to answer some questions. And we have had some questions come through in the chats, and my colleague Matilda has very kindly grouped them for me. So the first one is on global fragmentation. So in the context of accelerating climate risk, geopolitical fragmentation, and AI-driven disruption, how should boards reinterpret their fiduciary duties to ensure they are not only legally compliant, but also strategically positioned to safeguard long-term enterprise value and resilience? Big question, but touching on a few themes we've already discussed. So I don't know who wants to take that first.
Well, just taking those risks into consideration, I mean, that's how they should react, I would say, because of this fragmentation and instability.
Interesting. I guess we've discussed this question already, but what we haven't really picked up on that much in the webinar, which does come across in small doses in the Navigator, is that the flip side of risk is very much opportunity. They are two sides of the same coin. If you move early and take really decisive forward-thinking action in response to a risk, you are hopefully going to realize some value. So maybe let's focus on that angle of this question. So does anyone have any comments on how to realize value beyond compliance from the current regulatory and legal framework in any jurisdiction?
Well, Sarah, let me bring a point that is currently being discussed in Brazil due to the war that we have right now. Is the price of natural gas. So companies and boards who are already working on energy transition, they are ahead now and they have the opportunity not to suffer from the new prices from gas. But this is something that has to be included in the strategy of the company and be revised, and not only focused on the current price, because if these companies that have been working on new energy sources besides natural gas and besides oil, they were just focusing on the price when they started and all the burden that they would have to deal with in terms of the operation, to understand, to research, and to deploy their staff on that, they wouldn't have taken the opportunity to analyze and then go for new energy sources. Right now, they are in a much better competitive position than they would be.
Exactly, and that's the point I picked up on, and Daniela picked up on as well. There's opportunity in this, and being forward thinking and proactive instead of reactive. Does anyone else want to come in on the opportunities point?
Yeah, just a comment. Sorry, Jessie. That in Europe, these omnibuses were the complement of the so-called competitiveness compass. So the original idea of Europe was to boost economic growth by decarbonization, by innovation, by reduction of dependencies. So basically, the original aim of the omnibuses was to simplify regulation in order to boost competitiveness and growth.
Yeah.
So.
And I would say on the EU, where we've landed with the omnibus, of course, it has many faults. It's massively reduced in scope and ambition, but we do have clarity now going forward. We've got simplified standards which will make compliance hopefully easier and less costly for boards. And also, it lowers the entry point for voluntary action as well. So the companies that fall out of scope, there's clear guidelines there that they can strive to adopt on a voluntary basis as well.
Yeah,
Jessie, yeah.
Sorry, just one point on this. Companies out of the scope. Okay, it's still. It's a voluntary way of disclosing information on these topics, but it is necessary because, as we have seen, banks have been imposed the penalties because they didn't rightly assess climate risks. So in the Navigator, I mentioned the Banca Corporación Bancaria case, this Spanish bank that was imposed this penalty. So what's the meaning? If the ECB imposes penalties on banks because banks do not assess rightly climate risk, this means that banks need more information from clients, also from small companies that are out of the scope. So companies, if they want to have access to banking loans, they shall disclose these topics. And banks will still require them to do so, despite legislation is not voluntarily. Otherwise, they will get imposed sanctions or penalties by the ECB. So, it's in their interest doing so.
Yeah, and that's a really good point, Sabrina. The demands for this data are coming not just from regulators, banks, insurers. They're all taking exposure to climate-related risks and nature-related risks, including liability risks in some cases, into their risk assessment and due diligence processes. So yeah, that's a really good point to highlight.
Sarah, I want to
Yes,
put the view from Latin America, because here we are more nature dependent. So we must, in many sectors, we are working, the boards are working in a very high level and on climate risk and climate nature related risk, for example, and very many sectors we have severe water stress. They are moving completely the business. For example, agriculture, for example, in mining sectors that are very, very important in Chile, but also in other countries. So the board's member, they must be prepared to understand which is the real risk, not the demand from the regulator, but he must understand which one is the risk, the amount of the financial impact in the business, and what are the strategy they must impulse from the board, not only the management. The board must put his voice very loud and clear to make huge decisions. So in here we have more we are more affected in Chile in particular by many physical evidence from climate change. So that's our view in the boards in Chile.
Yeah, and I mean, Dina, thank you so much that you picked up on something about quantifying and measuring the risk. That, I mean, that's something that is inherently hard to do, and it's often a challenge, because you can talk about these risks being conceptually material and recognizing the materiality without actually being able to put a value on how much it's going to hit your bottom line. Does anyone have any thoughts on how to approach that for companies who are starting out on the compliance and reporting process?
Good, Sarah. From the commercial side, I think quantifying in financial terms, I know that's really hard, or tax avoidance, tax implications, or fines. Unfortunately, companies respond to, particularly in the US, to the avoided fines and risk litigation as well, or pro-tax favorability for benefits. So prior roles as Chief Sustainability Officer, we've had to quantify total taxes saved or tax abatement as well as avoided risk, but also the likelihood of getting a new license to operate in new jurisdictions as well was pretty significant. And through measurement, through social license to operate as well, putting value around that too.
That's fascinating, Gwen. I'd love to talk to you more about that. And I can see that people in the chat also have strong views on this as well. Let's move on to another question. We've had someone ask for which law firms are giving the most resilient advice on insurance. I'm not going to touch on that one because we've got lots of different law firms represented here. Question maybe for the lawyers, and do you consider that due diligence in human rights can reshape the business judgment rule?
No, it actually reminds me of the question earlier too about like how do we reimagine or whatever the verb was, the fiduciary duties. I think we have to in some ways stop thinking that emerging climate risks and opportunities, nature-related opportunities, human rights and supply chains, things like this are going to reshape the rules. They're not any more than seeing a bus full of refugees on a highway are going to reshape the rules by which you drive, or seeing, climate risks on the road. The rules are what they are. And so really fundamentally what we're asking is how do we get imaginative enough about the application of rules that are not going anywhere to understand what their sweep can be in terms of seizing opportunities and identifying risks in a way that is itself less risky than trying to stick your head in the sand and avoid them. If we think that ultimately the liability risks of inaction are less probable than they are if you take action. That's what you have there is a misalignment of the incentives, and so it's not fundamentally about like, are we going to reimagine these rules? If there's regulation that says that something has to be done, like human rights due diligence, then even in a place like the US that is somewhat rule averse, you'll see that happen, but it won't change the fundamental rules of the road about, what are the fiduciary duties, or what is the business judgment rule. I think it's really ultimately about how imaginative companies can be about identifying and disclosing and connecting these risks and opportunities to the overall well-being of the company, its long-term value generation, et cetera.
Brilliant. Thank you, Jessie. Does anyone else want to come in on that point?
Just recalling maybe on human rights that in the Mille Defiance and Shell case, the Court of Appeal actually recognized for the first time that protection of the environment is a human right that has to be applied horizontally between private parties. There is citizens on one side, companies on the other side. And this, I think, gives room for lawsuits that can make reference to human rights as the ground to sue companies that pollute.
Excellent. And it's quite a big question, but I'm being prompted in the chat. How do you think the recent International Court of Justice advisory opinion on climate change impacts directors' duties? Of course, that was an advisory opinion that came out last year, which said that states have positive obligations to mitigate and protect their citizens against the impacts of climate change and could be held liable for failing to do so. Does anyone have any closing remarks on how that affects directors in practice or in theory?
Closing remarks should be optimist. When we answer the question, we won't have good words, at least from a Brazilian perspective. It doesn't affect at all board's activities and Brazil. If we are not able to link nature and climate risks and opportunities to the business itself, to the business strategy, it doesn't get relevant at all. It will not be on the board agenda. So I'm a lawyer, so I'm telling this. I know it's not good to hear that, but it doesn't impact at all. Maybe in the future, but right now I don't see anything like that.
Yeah, I tend to agree. The theoretical response is different, but this webinar is focused on practicality. So we've got 2 minutes left. So it's time to close. I want to thank you all so much for your participation, not just in today's webinar, but also in producing the Directors Duties Navigator. It was a slog at times, but I learned so much from working with you all, and I do really I think that everyone who reads the Navigator feels the same. In terms of all the participants, thank you so much for coming. An hour and a half is quite long, but I do hope you got value out of this as well. We will be sharing a survey to get some feedback from you. We greatly appreciate it, so we can keep improving the content and structure of these sessions. Finally, we urge you to take a look at the Navigator and various resources on Chapter Zero and CCLI's websites. Please do reach out to me, or I'm sure any of the other panelists would love to connect if you have any follow-up questions. I know the chat's been popping off. I look forward to reading it afterwards. So unless anyone has any final optimistic perhaps remarks, we can give you release you back to your mornings or afternoons or evenings with 1 minute to spare. Thank you all so much.
Thanks so much. Have a great day.
Likewise. Bye everyone.
Bye. Thank you. Bye bye.